What if the government could permanently strip you of your Second Amendment rights, not because you were caught committing any violent acts, but simply because you were doing something that the government did not like? That's exactly the question at the center of a new case that was just granted review by the Supreme Court today in a case called U.S. versus Hamani. So let's talk about this new critical Second Amendment case that was just granted review. Now, before we jump into this video, if you want to support the channel, one of the best ways to do that is to simply subscribe to the channel. That, of course, helps the channel to grow. Also, double check to make sure YouTube is not unsubscribed to you because they love to do that, especially on two-way channels. And then I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, AOR is in a league of their own. They're always expanding their benefits. Check them out using the links down below. And I highly recommend you sign up this year because you lock in your price for this year and a few years going forward. And next year, they're going to be increasing some of their prices. So I highly recommend, if you're interested, check them out, lock in your price this year. And if you use my code ARMEDSCHOLAR, you can get $50 off an individual sign-up plan or $25 off of a family plan. As I mentioned in the intro, in this video, we're going to be discussing a critical Second Amendment challenge that was just granted review by the Supreme Court. This case seeks to force the Supreme Court to determine who are the people mentioned in the text of the Second Amendment. This case revolves around 18 U.S.C. section 922 G3 and its restrictions on the unlawful use of controlled substances. Now, this question is whether the federal law here violates the Second Amendment. And the primary battle in this case is not necessarily about, controlled substances or necessarily their use, but primarily who are the people afforded 2A protections and when can the government restrict your 2A rights based on them thinking that you're an unlawful user or potentially trying to classify you as a non-law abiding citizen. The question in this case is, does the Constitution protect only so-called law-abiding responsible citizens that the government gets to define on their own, or does it apply to all people unless there is clear proof that that person is a danger? Now, recently, the Fifth Circuit Court of Appeals threw the challenge out against Mr. Hamani, saying that under its own precedent, the law can't be applied to someone who wasn't actively intoxicated when they possessed a gun. This case has now made its way to the United States Supreme Court, and today the Supreme Court granted review to this case. This creates another significant Second Amendment challenge that the Supreme Court will hear and decide on this term. So who is Mr. Ali Hamani and what is involved in this case and why is it being granted review by the Supreme Court? Well, from the outset, I will state that Mr. Hamani does not seem like a great person. He's not a favorable plaintiff. The facts in this case are not favorable, so I also have a lot of hesitation about this challenge. These are typically the type of factual cases that the federal government likes to push to the Supreme Court because the plaintiff here does not look like a favorable person. They look horrible. And because of that, this government can try to get a win in their favor just based on the facts. Now, Mr. Hamani is a dual citizen, so he's a citizen of the United States, but also Pakistan, and he was also on the FBI's active watch list. In 2019, a search of his phone at a border crossing uncovered communications suggesting that he was prepared to commit fraud on behalf of people tied to Iran and other extremist groups. Now, because of this, the FBI also uncovered evidence that he was both using and selling illegal drugs, and in response to his activity, the FBI obtained a warrant to search his home. Now, when agents searched his family home, they found a Glock, roughly 60 grams of marijuana, and then several grams of cocaine. Now, Mr. Hamani admitted that he smoked marijuana nearly every other day. He wasn't smoking at that time. He wasn't using drugs at that time, specifically when they raided him. Now, this federal law that we're talking about is one of those ones that you see as the standard question that also pops up on your 4473, asking if you are addicted to, drugs, if you're an unlawful user of drugs. So that's one of those questions that you see pop up on the 4473, and it's this federal law that's being challenged based on the Second Amendment. Now, in the district court, he filed a motion to dismiss the charges, arguing that after Bruin and Rahimi, the Second Amendment does not allow a blanket ban like Section 922 G3. Now, the trial court actually agreed with him and dismissed the indictment. Now, on appeal, the Fifth Circuit also affirmed that dismissal based on the Second Amendment and then also some of the Fifth Circuit precedent. That left really the Trump DOJ and the DOJ here only with one option, and that was to take this case up to the Supreme Court. And in June of 2025, the Trump DOJ filed a petition for review to the Supreme Court, and the case went to conference in front of the Supreme Court on September 29th. Well, today we just got an order from the Supreme Court, and they granted review to this case. So the question the Supreme Court will now answer in this challenge is whether 18 U.S.C. section 922G3, the federal statute that prohibits the possession of firearms by a person who is an unlawful user of or addicted to any controlled substance, violates the Second Amendment as applied to the individual here, Mr. Hamani. So what does the DOJ argue in their petition to the Supreme Court? Well, first they argue that history and tradition supports disarming people considered dangerous, including habitual drug users. They point to laws restricting guns from intoxicated individuals, the mentally ill, and then other individuals as well. Second, they say Section 922G3 is not permanent. It's only a temporary restriction while you're under the use of those drugs, while you're potentially addicted, and once you get clean, you are no longer banned under this federal law. Third, they highlight a growing circuit split also on this issue, and they point to the fact that just last term, the Supreme Court addressed prohibited persons and this whole question in Rahimi. And so that's also why they were pushing the Supreme Court to grant review to this, to expand upon what they said in Rahimi. Now, I will state once again, my big issue with this case is the fact pattern here and then also the plaintiff. Like the Rahimi case, we have a very bad plaintiff and the facts in this case are not great for the two-way cause. If anything, this plaintiff here, Mr. Hamani, is even worse than the plaintiff that we saw in the Rahimi case. However, I do think that the court here in this case will try to do the same thing that we saw them do in the Rahimi challenge. They will try to narrow their ruling as much as possible to make it a pro-2A ruling and potentially leave any loss isolated to just as applied to Mr. Hamani and his specific facts. The big concern with that is that we may also get some bad language in this ruling like we did with the Rahimi decision, and that bad language can then be used by other lower courts to violate other 2A rights. Like we saw in the Rahimi case where they mentioned the more nuanced approach or, looking at things based on societal changes. That nuanced approach is now being used by lower courts in other 2A cases to try to justify federal and state restrictions. So the big question that the Supreme Court will now have to answer in this case is, does the Constitution protect only so-called law-abiding responsible citizens as defined by the federal government themselves, or does it apply to all people unless there is a clear proof of danger or that that person is a danger to society? This case will now force the Supreme Court to answer that very question, and the ruling won't just affect one man in Texas. It could set the boundaries of the Second Amendment for millions of Americans who want to own guns, potentially also engage in other activities. So this case will also apply the whole Bruin and Rahimi standards to this challenge, which will not only just flush out those issues even more, but likely include other language that could impact some other 2A cases going forward that don't necessarily directly involve prohibited people and those other 2A issues. This could be, language that potentially impacts other 2A topics going forward, like rifle bans, magazine bans, concealed carry restrictions, and other issues as well. So now we're going to be watching closely to see, how does this case move forward, what is argued, what amicus briefs are filed, and then we're going to be waiting to see, the oral arguments get set. But like I said, the Supreme Court has granted review to another significant Second Amendment case. This case, again, deals with prohibited persons, like the Rahimi case, deals with a different federal law, other than what was dealt with Rahimi, because that was based on a domestic violence restraining order. This case is dealing with other prohibited people based on controlled substances. But again, the Supreme Court this term will jump into another 2A case dealing with prohibited people and who technically are the people as defined in the Second Amendment. So as we get more information, as this develops, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that, of course, is to subscribe to the channel. Also, you can check out my website, ARMEDSCHOLAR.com. Over there, we have a lot for you guys that you can check out. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.